something else that happened in court today. Former President Jacob Zuma back in the High Court in Pietermaritzburg to try and have the advocate Billy Downer removed from his arms deal corruption matter. Let's get the view of legal analyst Modidima Mannya. A very good evening to you, sir. Good to have your time as always. So from what was argued today, much of it sounded very similar to the arguments that Zuma raised in previous matters against Downer, which he has lost. Among the things that he was raising is the allegation of bias, and he claims that Downer, for example, was fueling the media frenzy around the former president. Has anything changed in his strategy?
Yes, good evening and good evening to your viewers. Look, not much has changed. Of course, there's some additional new things, new old stuff, because part of the argument now is the conversation that Mr. Downer had with Mr. Sam Sole of the Mail and Guardian. And Mr. Zuma seems to suggest that Mr. Downer gave out information. But you must remember this happened somewhere way back in 2008. We are now in 2023, and this is now becoming an issue. But the sum total of what Mr. Zuma is arguing is he says that as long as Mr. Downer is the lead prosecutor, he stands not to get a fair trial. And he's saying to the court, amongst others, why doesn't the NPA just remove him, put somebody else, and then we can go on with our lives? And that's what the state is opposing. But generally, everything he's saying is a repetition of what the courts have already ruled on. You must remember that this matter came before Judge Koon as a special plea. And amongst others, the heart of it was Mr. Downer's title to prosecute. And the judge found that actually Mr. Downer did not in any way leak or release any personal information or medical information of Mr. Zuma. Then the issue came up in the private prosecution matter before the full bench. And the same, almost regurgitating the same argument, the full bench ruled against him. The matter went to the Supreme Court of Appeal. All this, and this involves about 9 judges, all of them say we can't find even the slightest shred of evidence that Mr. Downer misconducted himself. So we're back to square one.
So if we're back to square one and much of what's being argued is the same, what would lead anyone to believe that a court, the High Court in Pietermaritzburg, would reach a different conclusion this time?
Well, that's exactly the point, because almost everything that is being argued now forms the subject of a judgment of one or the other court. Now, this court, for instance, cannot reverse a judgment of the full bench. This is a single bench judge. This judge cannot rule opposite to what the Supreme Court of Appeal has ruled on the same facts. So it's probably some bit of a futile exercise. I think those who may say this is a reincarnation of Stalingrad might not be perfect.
And then, as far as legal avenues are concerned, you mentioned Stalingrad. Advocate Mbofu, arguing for former President Zuma, said today that even that is an unfair accusation or characterization, and I'm paraphrasing here, of all the legal avenues he's explored on this. How much further can he go? Because at this point, it feels as though the question is similar to just asking, how long is a piece of string?
Yes, remember, in the private prosecution matter, the court took an extraordinary step of saying any further litigation must be with the leave of the court. Of course, he is appealing that. Now, the Supreme Court of Appeal itself has said that this right to access justice is not unlimited. It cannot happen in circumstances where the due process of the court is being abused. And I think we're going to reach a stage very soon where the avenues will close, not because he doesn't have a right of access to justice, but because the court will feel that this process is being abused. I think we're almost there.
So if the Zuma team is saying, as it argued today, that Advocate Downer could have basically saved this whole process and allowed the trial to proceed by simply moving away from this case, is there merit to that argument? Would it be, even if he feels as though he's done nothing wrong, would it be worth it for Downer to just say, in the interest of this case actually going ahead, let me leave it to another senior prosecutor? Would that be a fair expectation?
Well, by the way, maybe the public may not be aware that Mr. Downer is actually retired. And the National Prosecuting Authority has retained him to prosecute this matter. And as people know, this matter dates back to around 2007. Mr. Downer has been the coordinator of this whole exercise. He's consulted with witnesses. He was the one giving guidance. He's the senior counsel. And just to simply come with a proposition that says, look, man, just go, we'll get somebody else, it's a bit of an unintelligible argument. The question should be, and all of us must be concerned, Tembeta, whether I should choose which prosecutor to prosecute me, because that then is the end of our administration of justice. By all means, if there's evidence, and I've said this before, if there's evidence that Mr. Downer has misconducted himself, he must be disqualified. But if there's no evidence that he has misconducted himself, there's no reason to even think about him leaving. We cannot decide for the prosecuting authority who should prosecute us. It's a convenience issue. By the way, the trial is not conducted by Mr. Downer, it's conducted by a judge. So whatever presentations and submissions Mr. Downer makes are subject to the assessment of the judge. If in the proceedings Mr. Downer misconducts himself, the judge is there to make sure that Mr. Zuma's fair trial rights are protected. So I don't understand what is the significance of not having him. He must be there. That's what the National Prosecuting Authority has decided.
So, former President Zuma has repeatedly said that he's exploring all of these legal avenues in pursuit of the protection of his rights. He's not the only accused in the arms deal matter. At what point, then, do his legal pursuits begin to disadvantage or perhaps go against the rights of his co-accused to a point where they are denied a speedy and fair trial as a result of the sideshow?
You know, Kambega, I'm sorry to say this. I'm not sure what the outcome of this trial, if it ever happens, is going to be, and I mean its effect, because it has taken over 3 decades now. I'm not even sure whether, you know, it still has got a meaning. But suffice to indicate that there is a procedure in terms whereof the trial of Mr. Zuma and that of Charles can be separated. I don't know why that has not happened, because in those instances where you have got multiple accused and the trial can't proceed because of one or the other accused, either because of ill health or any other condition, you can separate the trial. So I'm not sure why it's not been separated. But I suppose to the extent that the trial doesn't even start, all the accused benefit. They will never have a conviction.
Right. Good to speak to you, Mr. Modidima Mannya. Good to have your analysis, as always, on the Zuma arms deal matter. More Zuma versus Downer, as it still is at this state.